Your Honor, yesterday afternoon, Mr. Miller, Bill Miller, one of the co-counsel for Ms. Wuornos, and I had a brief conversation. He indicated there were certain parts of the Wuornos confession tapes, both the original tape before the lawyer came in, and then the second tape that began after the lawyer came in which he felt there were areas of objection. He began to tell them to me, and I asked him if he would just write them down, give me a page reference, so depending upon what the court's ruling was, we could attempt to edit the parts that the court indicated that shouldn't come in. There were really primarily just several categories. One were comments where she said, "I'm guilty," or "I did it," things like that. Another where she refers specifically, "I deserve the electric chair, I deserve to be punished, I'll be hung in public," things like that. Those are two categories, very close to the label. Another category was where she mentioned to her public defender that she had a concealed weapons charge, and that was a warrant she was in there on at the time of that tape, where she mentioned she had a public defender. And then a question was asked her about other bodies being discovered in Georgia. And then finally, there were references to 1974 arrests and going to jail for 10 days. I believe that is, and if I might, for its invitation for court use only, have a copy of the list marked and set it by the court as being the original list that was provided to me, referencing the pages.
Your Honor, if I could elaborate just a little bit, I would point out that we did address the court yesterday. Yes. The court made certain rulings on the basis of these portions which we wish to be redacted from the record. Yes. The court has ruled that the references to the electric chair and to the death penalty would remain in the confession over objection. That the references that Ms. Wuornos made to "I don't think I should live," things like that, would remain over objection. That the reference to the public defender's offices would remain, and I believe since what we had explained was, because that came out yesterday, that I was withdrawing my objection to those portions that would have happened with respect to those. Pardon? Oh, the gun charge was redacted. It's my understanding that was redacted. I'm just speaking of just the references to the public defender. That's correct. You also sustained the objection to Sorry. With that was the reference to the bodies discovered in Georgia, which Ms. Wuornos has never been tied to. In fact, she did not. That's come out. Yes, sir. As have the references to the arrest in 1974 under the name Sandra Ratch and going to jail for 10 days. And I believe also we had discussed there was a portion there where she mentions a forgery conviction, and that too was.
Yes, it's in that same statement.
Okay. I believe so. But in any event, it was, you had said you were going to listen for it when you guys did it, and it's also going to be redacted.
If it's a reference, it's not referenced by page or written down. I didn't sit down and listen to the whole thing here. Tape again. Only respond to specific objection.
Okay, well, I thought I'd raise that one as well. Yes, I think that is one of his page references, John. I'm not positive.
You want me to look?
Yes.
Yes, the forgery is on page 65 as indicated.
Okay.
Forgery warrant. Yes.
It is on page 65, that's correct. So that is also redacted.
Your handwriting in that.
I'm sure.
Reference, however I call it.
So that too has been redacted, the reference to 431 on that same page. That's page 65 of the transcript. And again, the complete list, because there were numerous mentions or numerous references to the death penalty, the electric chair, punishment in this thing. And of course, we have objected to all those things. The court has overruled those objections and is allowing them in. Additionally, I just want the record to be very clear that we are certainly not waiving our original objections to these statements or the Williams Rule objections to these statements.
Your Honor, what we did, and Bill and I together looked at this list again, and we circled in red the ones that you sustained. One is on page 5, one on page 49, one on page 65 of the transcript. And we, for the record, did redact those sections, John. Page 5 was a 16-second redaction that began at 10:21. The one shows up on page 49 of the transcript was a 30-second redaction, and it began at 1:44. And for clarity, it begins with the words, "Have you ever done this to anybody in Georgia?" And it ends with the sentence, "I can't tell you where it's at, I swear I don't know." Back to the first redaction, we blocked the words so it's clear from the record. The redaction on page 5, which is the first editing that I'm referring to, the 16-second editing, began with the words, "I have a charged concealed weapon back in '86," and it ends with the words, "Do you remember who your public defender was?"
Both of those are acceptable.
And the final redaction, Your Honor, on page 65, begins with the words, almost the whole page. She's talking about Susan Blahovic and a fake ID, and then it begins with the words, "How did you get that one?" And the redaction begins, I believe, with, "Oh Lord, let's see." And she goes on about birth certificates and some guy in the Keys, and it ends with the words, "She got away with having to go to jail on her damn ticket." So that's on page 65. That's a 1 minute and 20-second redaction commencing at 2:16 p.m. on the tape.
That too is acceptable. Subject to the other objections, yes. Yes, sir.
The entire tape ready to run. It is, Your Honor. We need to take up anything else.
Yes, Judge.
Very simple.
So as to not, if with the court's permission, so as to not do it once the jury comes in, we would reiterate our objection with regard to the voluntariness, waiver issues, and admissibility of the statements. We would do it, you're supposed to do it when the statements are introduced. They're about to be introduced, so we request the court's permission to raise that objection now.
That's what I want to do before we break the jury. Is there anything else we need to hear about?
Yes, Your Honor. In view of the Williams Rule objection and being ever aware of the potential for some appeals court somewhere, our Florida Supreme Court or higher, deciding that perhaps the collateral murders have become feature.
If we get there.
I'm sorry?
If we get there.
Maybe the jury may stop right here.
That's right.
We'll never know.
Well, Judge, we have counsel not to interrupt if you can, or let him finish what he said.
And it's all right. Thank you, Mr. Clark, for your protection. And I mean that. Mr. DeMore had protected me ever since he's been in the office, and I mean that in all sincerity.
I have to take all of it.
I know that, John. we would, in view of the Williams rule objection and the, I guess, arguable, and I would say that really in quotes, because anything's arguable, issue that perhaps this series of killings may become too much of a feature, we are offering at this time only Ms. Wuornos' confession as it relates to the Mallory homicide, eliminating discussions between her and the police detectives or her statements relating to any of the other homicides, and eliminating her generic statements, which we feel do apply to Mallory, but because they are couched in terms of plurality, they, and I feel all, for this reason, we eliminated those references as well. And we will have a witness to verify the authenticity.
A couple of things, Judge. As a preliminary matter, we have not had a chance to review any tape focusing solely on Mallory. So we don't know.
Why don't I get your excuse before we do that?
I think that's a good idea because we can't make a decision on whether or not that's acceptable.
I think it's about 20 minutes ago.
Bring Gary out here and make excuses. Very repeated, Your Honor. Ladies and gentlemen, we're having a little difficulty in our production right now, and rather than keep you back in the back room back there, I'm going to let you go out on the street, and it's anticipated to take us about 30 minutes. You will be in recess until 10:15, and it'll give you time to move around instead of staying back there. Do not enter the courtroom until the bailiff pages you. If we may go over a little bit past 10:15, is the point I would make. So we're here being recessed until 10:15, and we will immediately recess.
Your Honor, I think, yes, we should have this marked as an exhibit that the advocate received Madam Clerk, marked for
You're not going to leave me for this, are you?
No, Your Honor. In fact, we could be in recess.
Court being recessed until called by the attorney. Let me get the lights established so at the level that you're going to want when you decide which way to go. Gentlemen, I'm sorry.
Judge, if I can get this cranked up, I think we can. Judge, I don't think it's going to need to. I've been sitting here where the jury would be, and I don't think that they are going to interfere with the pictures. That would probably be the only thing that seems reflecting back in.
I can't turn this off. It's our I think, is that light in there too?
Yes, sir.
Sergeant?
the pot, after he sold the pot. Then he said, okay, you want to make your money now? Around probably 5 o'clock in the morning. I said, okay, well, it's pretty dark and I'm pretty drunk.
Throughout this area where
We passed I-35 about maybe a half an hour in the road. There was no stop.
And you're off of Wood Road. Describe to me the spot for the weekend. Small lawyer.
Dark. It's really hard to see to get in. We kind of drove Wood Road, where to go in, and drove back around the top road.
Okay, so you were looking for a cutoff in the woods.
Right.
Woods, there's already a trail.
Right. No, we got much to work. About 500 to get it done. So you get my answer.
Council, do we have some motions that need to be heard before we bring in the jury?
I don't know if they're necessarily motions or matters, Your Honor. For the record, we have had an opportunity to view a condensed version of the statement tape relating to the statements on which Judge Graziano has previously ruled. We had not had an opportunity to view it prior to this morning. We've reviewed it, we've conferred, and the defense is in essence, Mr. Tanner has also indicated to us that the state would like to present this tape to the jury in lieu of the full tape that Judge Graziano previously read. In all candor, Your Honor, we've had a difficult decision to make in this regard. However, given our position on the Williams Rule evidence that we've consistently taken throughout the trial, it would be untenable for us to not agree to the condensed tape.
It's your choice, sir.
Yes, Your Honor. But what I'm saying is we have felt very strongly all along that, with all due respect, that Your Honor's ruling on the Williams Rule evidence was the wrong ruling.
Certainly.
And given that view, and given that position that we've held all along, I think it's more legitimate for the jury to view the tape that the state has presented to us today. We would, so as to not interrupt, renew our objection with regard to the voluntariness waiver issues and the other issues relating to the admissibility of the statements. If Your Honor can just...
Yeah.
We also, there are some references on this tape that touch on the Williams Rule issues, and we would renew our objection to the Williams Rule evidence. I can run through those for Your Honor and for the record. Specifically, and the first one is one that there's not much that can be done about, but Detective Herzeppa does say something to the effect that the case that I'm talking about is the Mallory case. So, and throughout then the course of the taping itself, there are references to other cases. Ms. Wuornos says at one point, I got it all confused. At one point, and actually this one is one that's pretty substantial. Ms. Wuornos talks about an electric razor as related to Mallory. And given the state's proof here, the state did not connect the electric razor to Mr. Mallory, but connected it to another individual.
Your Honor, I believe Detective Herzeppa told that the electric razor was given to the lady's husband who ran on the hotel she stayed in, and that was Mallory's razor. There was also a different razor in another case. The razor being referred to was Mallory's razor.
Okay.
The hand razor wasn't.
Yes, yeah, he stayed on Mallory.
Right.
There's also one portion during the recording at which Sergeant Munster is flipping what are obviously photographs relating to other individuals. I understand that it'd be difficult for Mr. Tanner and Mr. DeMore to somehow splice Sergeant Munster out of this case or out of the tape. However, that would be the other thing that sort of relates to it. In any event, Judge, as to the references, whatever degree of vagueness or solidity they have on the tape, we renew our Williams Rule objection. For the record, and we also renew our objection to the admissibility of the statements, Your Honor.
All right, I ratify and affirm the order of Judge Graziano orally given on December 6, 1991, reduced to writing on December 11, 1991, filed with clerk on December 13, 1991, as to this tape. I'm not an appellate court, and I will not relinquish that ruling, but accepted and affirm it as the ruling of this court. Are we ready to proceed?
Yes, Judge, just one thing about the layout. The way I observed the tape was from the jury box, just because these monitors are larger, and it was, obviously Mr. Tanner and Mr. DeMore have a certain layout here in the courtroom. It might work better to have one camera that the jury can see, because I was sitting right in the middle, I was bouncing back and forth.
You mean TVs, Mr. Knowles?
Yeah, TVs. To have one in the middle so that all the jurors can focus and observe that instead of two with the speakers in the middle. Just kind
I've
of.
been sitting in this courtroom for 22 years, and I've never found any counsel who's ever agreed with anything that was ever done yet. So, I think you're going to check the record and bring in the jury.